Thank you, Madam Chair, and thank you to the witnesses for being here today. You spoke about the capacity and the way that you've tried to go after the increasing your capacity to deal with that inventory, high volume of asylum claims that have been caused by, a lot of things, inefficiency of the government, other things. But I want to talk a little bit about another aspect, which would be maybe reducing the amount of claims that we have, reducing the volume that's there. And so my first question is about the Safe Third Country Agreement. So do you agree with the position of the Government of Canada, and it's been stated here multiple times, that the United States is a safe third country?
That's a policy decision. I have no comment on that.
Well, I think it's been established by the government that it is. Would you agree that Great Britain has a functioning asylum system and maybe a charter level protection comparable to a country like the United States?
It's certainly a democratic country that has institutions that are fairly solid.
Okay. How many IRB resources, such as hearing and staff hours, would be consumed annually by claims originating from Great Britain, for example?
Not a whole lot. I don't think we have a huge caseload of we have in inventory 17 cases.
Okay, and what about people that arrive from Great Britain, transiting from Great Britain?
We have stats around country of alleged persecution, not necessarily country of transit.
So you have no idea when somebody, using Great Britain as an example, somebody arrives from there, you do not know that that's where they arrived from. You just track their country of origin?
We will know when we look at the case itself, but in data that we collect to do charts that look like this, we don't collect the country, the route that they took to come here, whether they went through 1, 2, or 3 countries before they arrived here. But we will consider it as part of listening to the claim and making a decision on the well-fundedness of the claim.
So to your knowledge, would there have been a decent number of claimants that would have transited through Great Britain, as an example?
I can come back and try. We don't have statistic on that. It's very difficult to offer a number.
Pardon, Monsieur le Président. Madame la Présidente, je pense qu'on a...
Apologies, Madam Chair. I believe that the interpretation has stopped.
I was hearing it properly, but perhaps we'll check with the translator. Thumbs up? Okay. Thank you.
Ça vient de
Merci.
revenir, oui. Voilà.
Started your time. Thank you.
So I guess what I'm getting at is, would there be any reduction in casework from your side if a claimant that transited from a country like Great Britain was automatically not allowed to proceed with the claim, having come from Great Britain, a safe country?
I think transit is not necessarily a sign of yes or no decision in and of itself. So
can I just stop you there?
Yes.
Isn't that how the U.S. Safe Third Country Agreement works?
the Safe Third and a list are two different things. We have an agreement with the states, we, the government, and we send back people.
So should we have an agreement with Great Britain, for example?
That not for me to decide.
Would it change the workload at IRB if there was an agreement like that?
Well, it would. Any agreement that, say, the government sends back people to a country would probably have an impact on the intake.
Okay, so another angle, there have been cases of misrepresentation, deliberate misrepresentation to an officer, and of course that undermines the integrity of the system. And we're not talking mistakes and errors; it's deliberately lying for fraudulent means. What proportion of Immigration Appeal Division appeals involve findings of deliberate misrepresentation?
We look at it from the point of view of credibility, and if there's, and there could be people misrepresenting their country of nationality or representing the nature of their claim or having documents that are proven to be in effect.
But I guess what I asked was, do you have a number? Do you have a proportion of people that misrepresent in their cases? Do you know that?
We have manifestly unfunded claims findings that we can have, and it's about.
Is that a statistic?
Yeah, that's a number, and
Is that something that's published, or is it something?
I have the stats. I just don't rely on my memory. Let me.
You can just table that with the committee. That would be fine if you did that.
Okay.
So I guess So what you're saying is that if somebody misrepresents themselves, that doesn't automatically mean that you will deny the appeal. You'll still continue to process even if they lie to you?
That's the whole thing about having a hearing. So you have someone, they come, they ask refugee status, they have to prove their claim. They have to prove who they are. They have to prove that they have a well-founded fear of persecution for one other ground. They have to have evidence to support it, and they have to be able to show lack of state protection. Now, sometimes we find that people have fraudulent documents. We say no to those.
Okay, so that's good. I have a little limited time, so I got one more question. Sometimes people leave the country, they file an asylum claim, leave the country, go back home or to a different country, and they're not around for their hearing. This happens, is it correct?
We decided then we make an abandonment hearing and we
And so
close
that-
the file.
Are those claims automatically abandoned?
We close the file.
So they're, if you leave
Well,
the country,
they have a
your
chance
claim
to
is done.
come. If they don't come, if they don't show up, the case is declared abandoned.
And does that happen all the
it-
time, or is there conditions around that?
There's no conditions. I mean, if you don't show up for your hearing and you've been called to come to your hearing, you have,
What if you've at one point returned back to your country and now you're back for the hearing? Does that automatically cause you to abandon the claim as well?
if they return to their country, they would have, well, the question that this would pose was the legitimacy of the claim. If you go back to your country
Right.
of persecution, that would put into question the veracity.
So
and
would that
the-
automatically be
Thank you so
disqualified?
much. You're way past your time, Mr. Redekop. So thank you.
Thank you, Madam Chair. Madam Broussard, just at the beginning you said, and I just want to make sure these numbers are right, you said that right now a new case referred to you will take 44 months to get through the system, and that there's about 290,000 cases in your system, and that these are, we've never seen numbers like this before. For two questions, is that correct? And then secondly, does that keep you up at night?
It's correct. The 290,000, a third of them, 103,000 are incomplete cases in the sense that we're missing documents in the file to be able to process it. So that's number one. 44 months, yes, it is something that I'm concerned with, and that's why we work so hard in reducing our times and trying to have my case, give training and videos
Yeah.
for claimants so that they know how to proceed and facilitate the case. Everything
Thank
we
you.
can do to shorten that time.
In the levels plan that was released yesterday, there was 115,000 additional spots for protected persons in Canada. Is it your understanding that will go to asylum seekers? Are you familiar with that, and have you talked to the department about that?
I have not talked to the department about that. My understanding, and then to be checked with IRCC, and it is for those who are found to be in person in need of protection. So not people with us, but people who got a positive decision from us.
Okay. I want to go back to what we were talking before about abandoned claims.
Yeah.
So I believe what you told me was that if somebody is not in the country when their hearing happens, that's essentially an automatic ending of their file, and the
Well,
file is closed.
There are many reasons for a claim to be abandoned, but what we primarily look at is we're calling you for a hearing and you're not here. We're going to call you for a special hearing to explain why you weren't here. And unless you have a good reason, your claim is going to be declared abandoned.
So then back to the example where somebody actually did leave the country, go back to their home country, and now they're back in Canada and they are available for their hearing. Does that automatically disqualify them as well?
Well, I would expect the minister representative to say that this person reavail themselves of the protection of their country and challenge the claim at the very least.
So they would likely have their claim abandoned, or is that something that needs to be strengthened in the law?
I'm not sure I follow exactly. Maybe you can help?
I think the issue is if they left the country and tried to come back, they'd be ineligible because they previously made a claim in Canada.
So it's less a question of abandoning it, but one of being eligible.
I see. When the minister was here, she talked about using the mass cancellation authority for fraudulent purposes. And one of the reasons I believe that would happen is if a whole bunch of people had the exact same reason for claiming asylum, and which is an indication of gaming the system of fraudulence. Do you have any numbers of claims where you've seen the exact same pattern of descriptions and it ends up being a fraudulent situation?
We don't have numbers per se. What I can tell you, though, about similar block, it's often more complex than it appears. If the minister finds, like the minister's representative, have a number of cases and see that the blocks are similar, and they tell us, we will make sure that in the hearings, the claimant is exposed to that and has to provide a valid reason. If we
So can I stop right there? Because
1 minute.
sorry, I have very limited time, but one idea that I want to suggest is, would it be better if the claimant actually had to make their claim when they arrive? Because my understanding is they don't necessarily have to. And further, what if there was video record of that claim that they made when they arrived? Would that help you?
There's a presumption that if you claim early, or if you claim late, rather, if you delay claiming, there's something questionable about your claim that maybe the fear is not so real. But it's a rebuttable presumption because the time that it takes to claim refugee status starts when the claim materializes. So if you came here as a visitor or as a worker and did not fear persecution, you won't have such a hearing or you won't have such a tape. So what's relevant, and it's not me saying it, it's instruction from the federal court really, is we look at delay. If the delay is explained, if there's a valid reason, then a delay in itself is not a valid, sufficient reason to decline a claim.
Does that happen often?
Thank you so much, Mr. Redekop. Thank you so much, Ms. Bressac. Next week.